Aye. Feeling for the state of Florida is now in session. John K. Starkville, judge presiding. All persons having been before the court with all near give attention and you will be heard. May God save the United States of America, state of Florida, in this honorable court. Please be seated.
Good morning. I'm Judge John Stargell, and to my left, I have Judge Petra Brownlee and Judge Mary Alice Nardella to my right. We have a couple cases before us this morning. Our first case will be Juan Carlos Martinez versus the state of Florida. I'd like to ask everybody in the audience if you please take your cell phones and turn them to off or to silent so that there's no interruptions with us today. And if I could just ask counsel at the table to please identify themselves and who you represent.
Good morning, my name is Cynthia Richards from the Attorney General's office, and I represent the state of Florida today.
Good morning, Robert Lee, Alan Lawrence, Bureau representing the appellate on.
Okay. And how much rebuttal time would you?
I have 5 minutes left.
Okay. Mr. Now I'll recognize you. First order of business is we were handed packet of information this morning that I understand was filed last night at 7:09. Did you provide that to opposing counsel?
I did. I emailed it to her last night and we got here early and gave it to her prior to the hearing. And I apologize for the last minute.
Well, I'll leave that to my colleagues, whether they want to consider it. I don't think it's fair for you to expect that they'll be able to respond effectively to it, even though they've had, at least 10 years on a couple of the cases and 8 years on another to be familiar with them, to not cite them in your briefs and to not provide it to the judges and parties in advance. I think makes it difficult for us to do much with it today, but with that being said, you're recognized.
I understand. I found them in my preparation, but I understand it would be much better practice to provide them in advance. May it please the court, my name is William Pinnell and I represent Juan Martinez, the appellant in this case. As noted in our briefs, it's our position that the trial court committed 4 separate errors. I'm going to start my focus today on issue 3, the denial of motion to suppress. Certainly, the court has questions about the other issues. I will address those. One housekeeping matter, I was going to address the notice of supplemental authority, but Your Honor took care of that. The other housekeeping matter I had was on page 16 of the state's answer brief. State argues that law enforcement conducted lengthy surveillance of Mr. Martinez in this case. From my reading of the search warrant affidavit, there was no evidence that they conducted surveillance of him or his house. So I think that's an inadvertent mistake by the state.
And counsel, we would look to the 4 corners of the, what was submitted to the magistrate to sign the warrant to determine if that was true or false, correct?
Correct, and my review of the 4 corners of that affidavit does not reflect any evidence of surveillance. As this court is aware, because the trial judge based his decision solely on the 4 corners of the affidavit, this court in Freeman says that this court's review is de novo. In a situation like this, according to the Cherry case, the second DCA 2021, they say the affidavit must state the affiant has personal knowledge of the confidential informant's veracity, or the affidavit must contain sufficient corroborating evidence. It's our position we have neither one of those things here. There's no evidence that the informant in this case is reliable or has a history of giving correct information. No evidence he's previously served as an informant, and no evidence corroborating that drugs would be found at the residence in question. For example, there could have been surveillance, like there is in some of the other cases, to see whether people were coming and going and staying for a short period of time, which is sometimes indicative of drug sales. There could have been trash pulls. There could have been controlled buys. None of those things are present in this case to corroborate the information that the CI provided to the agent in this case, or the
What
detective.
make of the fact that we're dealing with a cooperating defendant instead of an anonymous tip or anything like that?
So when you read the Sherry case, it's it's a similar situation where an individual is helping the police. I can't imagine a person, and I would cite the Castro case. The Garcia case talks about an individual who is working for the police has less reliability. I can't imagine a person who was just arrested by federal authorities on a separate charge involving heroin. I think that person would be the most likely to do anything they can to help themselves. So I would suggest that that's the most unreliable person you could have. On the other end of reliability would be an unconnected citizen who maybe was a neighbor who saw something and had no skin in the game. This
Counsel,
defendant,
let's talk about skin in the game, because that could be helpful. I know, is it your allegation that the cooperating defendant here, Mr. Castillo, had zero skin in the game? If he had given a false allegation against Mr. Martinez, is there any disincentive, any harm that would visit him? Let's talk about his,
sure.
his credibility from that angle. What is your position on that?
I mean, I don't know that he can be charged with perjury.
Right?
So
So
I
what
don't-
about like substantial assistant agreements falling through, or, and I know that's not in the record here, but it could be something like that.
Of course. But we don't have that in the four corners of the affidavit. So of course, if he had a substantial assistance agreement in federal court and gave incorrect information, then he could lose his substantial assistance credit. But again, we have a guy who was recently arrested who has every incentive in the world to point the finger at someone in the hope that he's correct. And he might know that this person was involved in drug trafficking in the past, and hope that he's right.
Yeah, what do we do with that fact? Is that fact relevant at all to
It's,
Mr. Martin? Go ahead.
the case law says it's relevant, but when you don't have dates or times, it's not really particularly material to evidence that the drugs will be found on that date. And based on the,
For that, we have his testimony. So we have some allegations, right? So he says, based upon my personal knowledge, right? Not based on something I heard, based on my personal knowledge, this
Sure.
morning I went to this house and this guy who was in this house tried to sell me 3 kilograms of cocaine. Right? And I know in the past, when I try to verify that information, that the gentleman that he's accusing of trying to sell him 3 kilograms of cocaine has been involved in similar endeavors. Correct? That evidence, his past acts, although they may not be relevant in a court of law to adjudicate his guilt, they are relevant to the magistrate in determining whether to issue.
the case law says, and this is the Castro case says, where there's not details on a defendant's arrest, that doesn't really corroborate anything.
Okay.
The Sanchez case says that it's relevant. And it's quote, it says, although the criminal history of a suspect can be a factor when determining whether probable cause exists, it does not show current drug sales were taking place at the residence when there was otherwise no such evidence. So, I mean, they're again talking about corroboration of the cooperating defendant or the informant. And I think we'd be in a different position if the affidavit said, the drug trafficking arrest was a couple weeks ago, even a year ago.
Well, this is interesting. Do you distinguish between corroboration of the crime alleged or just corroboration of the details that surround the crimes, right? So we have corroboration of who's in the house, right? We have
Of course.
corroboration of the color of the house, right? We have corroboration of those sorts of ancillary details. but there is no, is it your position there has to be corroboration of the crime that's being alleged by the cooperating defendant? Or there needs to be more ancillary details, the mosaic has to be better?
Well, I think corroboration of innocent details is not necessarily going to support probable cause. I mean, they just prove that the defendant lived there. And he knew that. And the cases talk about that. That what the cases focus on is there probable cause that contraband will be found in the residence on that day. And they talk about, again, controlled buys, surveillance, I think the best example of where a warrant properly establishes probable cause is the Laredo case, which is cited in Sherry. And they talk about the veracity and reliability of the two CIs in that case is corroborated by the 2-week surveillance of the defendant's residence. And where they saw vehicles coming and going to the residence, and those vehicles people only stayed for 5 to 10 minutes and left. So we don't have any of that.
Was that a trafficking case?
I believe
Or
it
was
was.
that, my question would be, it says here that on that day, unlike some of these other cases where you have people coming and going, maybe they're selling smaller amounts, or maybe they are trafficking amounts, but, this is on that day. So as a trial judge, they're looking at this, and this is what the individual is saying, is that today this happened. And they describe the details of the inside of the house, the tattoos on the individual, all the things that are going on there. What exactly more is it that you think you want our court to write a reversal and to be able to inform trial judges throughout our district what they need to do differently, what they need to be looking for, law enforcement, what they need to be writing different? So in this one, what additional factors are you saying they should have included?
A single fact that corroborates the CI's information about the drugs being in the house. I agree that it's not stale. It's from that day. So it's definitely not stale. But all the cases talk about, and I mean, the plain language of the Cherry case says the affiant must state that he has personal knowledge of the confidential informant's veracity, or the affidavit must contain sufficient corroborating evidence. And when they talk about the corroborating evidence, they don't talk about innocent details. So there's nothing in here. I get it. It's that day, and I get it. It's detailed, but there's nothing to suggest to the magistrate looking at this application that this particular individual is credible. And he has every reason in the world to accuse someone to try to work off his charges.
They drove them by that day, and he said, this is it.
Again, they prove that the probable cause that Mr. Martinez lived there. That the question, that's not the question before the magistrate. The question is there probable cause that contraband will be located on that date? And I think the search warrant affidavit in this case is woefully lacking on that issue. And again, we would be in a different situation, as Judge Bardella was asking about the criminal history, if the affidavit was more detailed and said, let's say, and I don't know whether this is true or not, if the affidavit says Mr. Martinez was arrested for trafficking at this house previously, I think now you have a more of a link, or if it was a recent trafficking arrest. But for all we know from the affidavit, because it's so conclusory on the trafficking offense, this could have occurred 25 years ago. Certainly, the fact that you were trafficking drugs 25 years ago doesn't mean you're trafficking drugs now. So for those reasons, we believe that the affidavit is woefully inadequate in this case. And I think the Cherry case is, other than the difference with the criminal history, it's very, very similar. So I'd ask the court to use that case as its guide to write its opinion reversing the decision in this case. And I'll reserve the rest of my time for rebuttal.
You recognized?
Good morning, Your Honors. Let me start out by pointing out a couple of things. To your point, Judge, what factor would this court need to include in its opinion to reverse? I would say that's exactly why we're here. There should not be a reversal because every factor that has been laid out in case law is present in the search warrant here today. The defense never claimed that Detective Sayence made a false statement, made a misleading statement. The application for search warrant, which the magistrate reviewed, had I'm sorry, word just left me. The informant in this case, Mr. Castillo, I believe his name was, said, I was there at 9 o'clock this morning. And Juan, I don't know his last name, but Juan tried to sell me 3 kilograms of cocaine. He was not getting a deal by the state, but it was against his penal interest because this is a trafficking case. And he had knowledge of the trafficking amounts of drugs and the person who had them, where they were in this case. So once the search warrant was executed and the Detective Sayence did take the informant by the house, said, well, his name's Juan, don't know his last name, looked him up in David, the law enforcement system, verified that Juan Martinez lived at that house, showed the informant a picture of the defendant who said, yep, that's him. That's the guy who tried to sell me the 3 kilos this morning.
Counsel, what in your mind does the law require us to know about the confidential informant?
The confidential informant, just.
Do we need to know, for example, like whether, is this a truthful person? Is this a person who has something on the line? Would this be a co-defendant in the case? I mean, what does it require?
Well, it requires that there has to be, the magistrate has to be able to know that the person making the application for the search warrant has reason to believe that a crime is going to be committed at a particular place at a particular time. That is all there. As far as the confidential informant, well, he wasn't, the cooperating witness goes, he had his penal interests at risk, as I said, because it's a trafficking case. So he was already arrested in a completely unrelated DEA drug case. Why he gave this information, I don't know. But the magistrate doesn't have to know if there's bad blood between a confidential informant or a cooperating witness and a defendant. That's not really relevant to whether or not there's going to be.
But counsel, doesn't that go to Mr. Pennell's point that if we don't know what his interests are, we can't determine whether or not it was against his penal interest or he had any other skin in the game? Is that just inference it's not allowed, or is that common sense?
Well, it's common sense because whether he had skin in the game or not, it was against his penal interest. And he could have been charged in a conspiracy to traffic because he knew where the drugs were. He knew he was selling them, he was,
Is
being
knowledge
offered to
enough
buy the
charge
drugs.
Somebody with conspiracy to traffic?
No, I said it could have been. That's why it's against his penal
Can
interest.
you build that out more? I don't understand that.
Well, because he had knowledge of drug sales in trafficking amounts occurring at this particular residence. He could also, once the state made their case and made the arrest and made the bust into the house to execute the search warrant, and the trafficking amounts of drug was there. Now he had the cooperating witnesses' own statement that he was aware of the amount of drugs and where they were, and was, being offered to buy them for his, so he could resell them or whatever he wanted to do with them. But they had his own admission that he knew all about the amount of the trafficking weight of drugs, where they were and who had them. So, but as far as just getting the search warrant goes, there is nothing. And the court clearly said in this case that they found that the appellant provided no proof whatsoever that Detective Sayence knowingly or intentionally omitted any material statements or merely submitting a federal search warrant, which is what happened in the motion to suppress, that was not sufficient to suppress a warrant in a completely unrelated case. The court also noted that the appellant didn't offer one shred of evidence that would mandate a Franks hearing. And after the testimony by Detective Sayence and Officer Combas, the court stated there was no doubt that appellant failed to prove by preponderance of the evidence that the detective failed to admit anything that appellant alleged he had. And in this case, there is one more note of interest here. I know defense didn't get into the first two issues, but there was a lot of noise made about the search warrant and on the judgment of acquittal arguments. the possession of paraphernalia, which was open and obvious on the dresser, the scale, the Pyrex cup with cocaine residue in it, the fork, all that, in the night table drawer, there was an argument made by defense about a bill that was 4 months old. If you look at page 357 of the record, there's a picture of this bill. It's not any bill. It is a mortgage for the property in question in this case in appellant's name. It has handwritten notes on this mortgage showing that the date of the mortgage was May of 2019. So it was 4 months old, but it had handwritten notes on that the mortgage was paid in March of 2019 and again in May of 2019. It was also in there with a prescription bottle that was at least a year old. So there is no doubt whatsoever that the house that was used, the trap house in this case on issue 3, can 100% be linked to the appellant in this case. Unless the appellant was paying a mortgage on that property for no reason whatsoever, which, you know, is not common sense. But that's why when the confidential informant said it's Juan and he's got the tattoos and he lives at this house, I don't know the number, but let me drive you there. And they looked up in David, that's how they could also identify that, yes, that was the appellant's house. And not only that, but this warrant, like I said, this all happened the same day. There is, to the detective's best of his knowledge from the informant, 3 kilograms of cocaine that defendant is actively trying to sell as of 9 o'clock that morning. There really is not the luxury of doing an in-depth, let's see if we can set up undercovers to meet somebody the defendant knows, and we'll try again in a month if we can get undercover buys. There's traffic amounts, 4 kilos in total of cocaine on that property. That is a risk to the community, and it was necessary. And to get the warrant that day to prevent the drugs from being sold, as the defendant was actively trying to do.
Counsel, what's your best case for the proposition that the exigency of the circumstance curtails the diligence of the officer?
I do not say that it curtailed any diligence. There
Maybe
was no.
curtails is the wrong word, but it seems like the argument you're making is that the exigency of the circumstance excuses a more detailed, and maybe excuses is the wrong word, but that you can do less to confirm a CI or a corroborating defendant if the circumstances are exigent.
I would not advocate that exigency unless it's normal police circumstances, fire, somebody screaming help. Not that issue aside, I am not averring that exigency in the sale of drugs, even in this amount, should reduce any of the required steps to get a search warrant. But we have all of those steps being taken in this case. And defense had said that there was no evidence that there was surveillance. But in the record, it does say, and I believe it was during the motion to suppress hearing, that the warrant was signed at, I believe, 8:05 p.m. in the evening, executed at 8:30. And there was officers in front of the house from 6 p.m. until 8:30 when the warrant was executed. So even after it was signed, the officers were there. I know it's 2 hours, but they were there for 2 hours, and they had already ascertained that this was the defendant. The cooperating witness was talking about, this was his address. They looked it up in David. They verified the address, the name. They verified who the defendant was with the cooperating witness through his photograph from David. Defense themselves admit there was no misleading statements. There was no false information given. And the magistrates, what they have to look at the time, and this is a warrant now, that there is probable cause that a crime is being committed at this location. And everything that was provided to the magistrate in that warrant that was corroborated, sorry, can't speak this morning, by Detective Sayance was accurate.
Counsel, would you agree with your opponent that everything that was corroborated was an innocent detail? I mean, he cast we have this, we have the cooperating defendant who
Mhm.
tells us of the crime.
Yep.
And then the verification of the cooperating defendant's veracity. The only thing we're able to verify, to my knowledge, is what counsel has described as innocent details. Would you disagree with that? And what would you say? It doesn't
No.
matter, so I'm gonna ask a twofold question. Would you disagree with describing the verification only of the innocent? I'll call them mosaic details. Would you disagree with that description? And two, does it even matter?
Well, I would disagree with calling them mosaic. I would
That's-
agree with the fact that there was corroboration of what was necessary for probable cause for the magistrate to issue a warrant. So yes, what the corroboration that Detective Science did, based on what the cooperating witness, the information he gave him, that was verified, and that was the grounds for probable cause in the warrant. So that I would absolutely agree with. And even though you're right, Judge Stargell, I was driving over from Clearwater last night, so I did not get the cases until this morning, but I am familiar with them, and I will just distinguish them by saying, in the Castro case, it was an anonymous tip that the search warrant was executed 7 days later. So that is not at all the situation we have here. And in the Sanchez, the detective said he did, quote, nothing. This was in the hearing to corroborate the tip he was given. Also not the circumstances we have in this case. And I believe the last case we have here was Laredo. And the court in Laredo said you have to show a probability that the contraband would be there that day. We have that exact scenario. The corroborating witness said, Mr. Martinez or Juan tried to sell me 3 kilos at 9 o'clock this morning at this address. Come here, I'll show you where it is. And then they verified, is this the guy that tried to sell it to you? Yep, that's the guy. So all of this unquestionably amounts to sufficient probable cause for a magistrate to believe that a crime was going to be committed at that address at that time. And on that note, Your Honor, unless there are any other questions for me, I will rest on my brief in this case.
Counsel, do you want to address the good faith exception, the argument that's,
I'm sorry,
would you like to address the good faith exception?
the what?
The good faith exception?
Yes, Your Honor, I will absolutely address the good faith exception. In that, even if the probable cause in the case were marginal, which I do not agree it is, the good faith exception would also apply because the officers in executing the warrant, they acted in objectively reasonable reliance that on the search warrant that was issued by a detached and neutral magistrate. You know,
Counsel, are there any, so the trial judge didn't rule on the good faith exception. Are there any factual disputes the trial judge would need to, and I'm guessing no, because the question is the face of the affidavit sufficiency, but I wanted to hear from you. Are there any disputes that the trial court would need to resolve if this court were to look at the good faith exception for the first time?
no, I don't believe there would be, Your Honor, because as I said, the case law in Florida, it has to be a reasonable probability that a crime is going to be committed in that location. And there was, by the defense's own admission, the Detective Science, the author of the application for the warrant, made no misleading statements. He did not make any false statements to the magistrate. To the best of his ability, he corroborated what the confidential or the cooperating witness told him, both through government records such as David and by driving by the house with the confidential informant to make sure that this is the location, this is the person you're talking about. And as Your Honor said herself this morning with defense, he described, he has tattoos. When you walk into his house, this is what you're going to see. Here's where the kitchen is. Here's where the bedroom is. Here's where I saw the.
Any of those details matter if they're not verified? For instance, like the internal layout of the house is interesting, but that's not verified.
You can't verify it until you get a warrant though, can you? I mean, like I said, there's no way unless you have somebody, the defendant himself going, yeah, that's my house and look, here's my cocaine. You have to go, and the magistrate has to go upon his reasonable belief that this is happening at this
So
location.
would it be your position that a common sense approach would say that the abundance of details lends credibility, even if only some of those details are verified?
The most important details were absolutely verified. This is the person who tried to sell me the cocaine. This is where he was, where he had the cocaine, where I was 9 o'clock this morning. And he has 3 kilos of cocaine. Now, there wound up being 4, but everything that a magistrate needed to find probable cause to issue the warrant in this case was there. And other than the defense being able to, like the lower court said, they offered no shred of evidence. They brought up in the motion to suppress hearing, they tried to enter into evidence a warrant in the DEA case, which has absolutely nothing whatsoever to do with this case. They're 2 unrelated cases, except for the fact that the cooperating witness was arrested on a separate DEA case. Now, whether or not, why he wanted to give this information about defendant, I don't know. But nobody could know that. There's no way to verify or be completely sure of why anyone volunteers information. So that
But that
cannot
can't be
a
right,
standard.
right? I mean, if someone does have a substantial assistance agreement or something else is going on, I keep coming back to that one,
Yeah.
then we could have something arguably in the record that could verify why someone would want to provide truthful information both to the police officers and then to the prosecution to cut a plea deal, to get a linear sentence, whatever it is. We could have a moment like that in the record, right? But that moment's absent here.
That is correct, Your Honor.
So what's the difference? I mean, I hear what you're saying about all of these corroborating details about the home and all of that. And I think in certain situations, we hear about innocent activity. I think in certain situations,
Mhm.
certain repeated innocent activity can give rise to probable cause. But if you look at the 4 corners of this affidavit, say I'm your best friend. And I know where you live because we spend every
Right.
Friday night watching TV together and having fun.
Right.
What's the difference between what we have in the 4 corners of this affidavit and me going up to a police officer if I get mad at you and saying, I know where she lives. I know her name. I know what her house looks like. I know what her telephone number is. I know she's on the mortgage. I know all of these details about her house. And guess what? She has a ton of marijuana in there. What is the difference between, there's nothing to make that truthful, right? I could just be mad at you as your friend.
That's correct.
But I have all these fabulous details about your house, but you don't have a bunch of marijuana in your house. So where's the link? How do I get to the fact that I would be telling the correct story about you? This, we can call it a citizen informant or confidential informant,
Right.
citizen witness rather, what is it?
Right.
Which I think matters that no one's really touched on, and I'm curious about that. But what gets me there to say, yeah, I think it's probable that she's got a bunch of marijuana in there.
Well, because none of those facts are in this record whatsoever. Nobody, like the defense said, there's no allegation by anybody that Detective Sands made any false statements. Nobody has said, well, it's not true, because clearly it is true. But what would stop somebody from doing that is being arrested for filing a false report, for one thing. So that would be a criminal consequence to
So
lying.
in this world, every person would have skin in the game. Every person that avers something about a crime being committed by somebody else has skin in the game.
Possibly, or they could mind their own business and, but somebody's mindset cannot be verified. But by
But
saying,
let's assume his mindset, let's assume everything's true. Because I hear you saying the officer's not lying. We don't have any evidence
Right.
of that. Fine. Let's say all of these statements are true. We still have to consider, right, whether these true statements are sufficient to give rise to probable cause.
to probable cause, not beyond all doubt, like in a trial court.
Okay.
Like I said, the magistrate in all case law in the state, probable cause is the magistrate has to have a good faith belief that there's a crime going to be committed at this address. And there was the confidential informant, whatever his mentality was for giving this information, there were penal interests against him, should he lie. But not only that, you can't turn around and then mandate a court that no one can issue a search warrant unless there is a deal in place with the state, or unless you can put somebody on a lie detector test or ask them, how do you know that that's true? Did he date your ex-wife? That's not a standard we can
But
hold.
couldn't you have
magistrates to.
couldn't you have one corroborating fact, like a trash pull, like a buy, you saw two people go in and out within 10 minutes?
Well, they also, between 6 o'clock and when the officers pulled up, there were people backing out of the driveway. They also verified, as Your Honor pointed out, that this is not his first rodeo. He has been convicted before of selling cocaine. So this is not a random, Sue Ann at the, junior league that somebody doesn't like her cookies, so is informing on her. This is a verified informant who has penal interests against him, described the house, described the person, described the drugs, and they were all there. Like I said, you can't have a standard of requiring the court, the magistrate, to know somebody's rationale or reason for doing something before they issue a warrant. And you can't ask a magistrate to only issue a probable cause warrant if the cooperating witness or co-defendant has made a deal with the state or has something tangible in writing saying you're going to jail if any of this proves to be false. Because the other possibility, even though it didn't happen here, is between 9 a.m. and 8:30 at night when they did the warrant, there was a possibility that the defendant could have sold the 4 kilos of cocaine. And that would be a different argument. He didn't, and it was there, just like the cooperating witness said. But no matter, that is why there's just probable cause for a crime at this address. Because you could never, if you issued a warrant right now, by the time the police got 10 blocks down, you don't know that they haven't flushed it, sold it, whatever. There's never a guarantee. All we can go on is what a magistrate has to look at objectively in the 4 corners of the document and say, okay, yeah, that's there, that's there, that's there. All right, signed off on it. And with the good faith exception, even if there had been an issue with it now, the officers that executed that search warrant were operating under the belief that an impartial magistrate had authorized the search warrant, and they were well within their rights to execute it.
Thank you, Counselor. Your time's expired.
Thank you, Your Honors. I appreciate your time.
May it please the court. Initially, I want to make it clear, we're not arguing that there's any improper omissions or false statements. We're not arguing on Frank's issue. So
We understand, counsel.
So, secondly, I disagree that there's a statement against penal interest in this case, as Judge Nardella indicated. Just the fact that someone witnessed drugs in a house and was in the house doesn't expose them to criminal liability. So I agree that there's case law that says where you make a statement that puts you in danger of being charged with crimes, makes them more reliable. I just don't think we have that.
Let me ask you this, though. I mean, he was there that morning. You didn't know if they weren't surveilling the house, that there's other things that are going to tie him to it, to make him potentially criminally liable for them telling other people, yeah, I got somebody else who's interested in this. So if he's feeling like he might be tied to it, isn't that a potential issue as far as?
I think the case laws say it has to be a statement against penal interest. So I don't, if he said, I thought I was going to be tied to it because of this, and this, maybe, but he didn't say that. He said, I was there and I saw it. So I don't.
Trying to second guess into what you want the magistrate to read into it. So if they feel like
don't want him to read anything into it. I want him to read the plain language of the affidavit, and he makes the statement that I was there and I saw drugs, which is not a crime.
But you're getting into what his potential penal interest is. And he's a co-defendant. So
I think we need more to say that this statement's subjected to penal interest. I think the case law is clear, and the Gillette case cited in our initial brief says corroboration of easily accessible info does not establish informant's credibility. So the fact that they corroborated that Mr. Martinez lived there, that's something that's easy to corroborate. So that's doesn't get it done. And what I
Does
really.
corroborating like the requirement for corroborating evidence matter based on how we label him? So if he is a cooperating witness, as the state says, or a confidential informant, as I think you all have called him, does that matter for purposes of determining his own veracity or the requirement for corroboration? Is that something we should consider?
I think it could, but if you look at the Sherry case or the Cherry case from the second DCA, it's a named individual in the search warrant application, and they still treat it the same as a confidential informant. So I think that's the proper analysis in this case. I think we would have a different analysis if we were talking about a neighbor who had no skin in the game, was not charged with a crime, and was not cooperating with the police in an effort to work off his charges. So I think in this case, he should be treated as a confidential informant under the Cherry case. I think the biggest thing we're missing, and there's no one-day exception under the Fourth Amendment. Doesn't mean because he said it today and the drugs were in the house today, we don't have to corroborate it. There's no case that says that I'm aware of. It's been the law since 1983 from Illinois versus Gates, that there has to be corroboration or indicia of reliability from an informant. And we don't have any of that. And that's what the Fourth Amendment requires. We can talk about all the details in the world about what's in the affidavit, but as Judge Brownlee noted, that's consistent with best friends watching movies on Friday night. So we're missing this corroboration, and that's the reason why there's no probable cause here. I would ask the court to look at the Blue case, which also talks about which is cited in our brief, talks about statement against penal interest, and
But that's all they had in blue. There's more here than there was in blue.
no, I'm just relying on their discussion of whether it's a statement against
Fair.
penal interest. I understand that. So, and I would ask the court to closely look at the Cherry case. I don't think there's really much difference between that case and this case. In fact, much of the language in the search warrant affidavit is similar, mostly probably because it's the same law enforcement agency. I think it's very analogous. And finally, as to the good faith exception, we have an experienced detective. Like citizens, law enforcement are charged with knowledge of the law. This officer should have known that this affidavit was deficient. So the good faith exception does not apply, like it did not apply in the Cherry case. So for those reasons, we'd ask the court to reverse the order denying the motion to suppress and reverse Mr. Martinez's convictions.
thank you, counsel.
Thank you.
We'll be in recess for about 10 minutes.
Oh, no. Yeah, yeah.
Yes. Take your bet. All right. May be seated. Board is back in session. Our second case today is 24-15-12 Osceola County versus Orange County et al. And if I could please have counsel at the tables identify themselves.
Yes, Robin. Lee Barbaugh here for the appellate English County, Florida.
Kimberly Cole for Osceola County.
Okay. All right, and how much time would you like to reserve for rebuttal? Okay. Just remind everybody, please turn your phones back off if you turn them on during the break. And Ms. Foley, you're recognized.
May it please the court, Beverly Pohl from Nelson Mullins for Osceola County. Somewhat ironically, this is a case that's a dispute between two Florida counties that have worked cooperatively for 30 years on the subject of the Split Oak Forest Mitigation Park. They've entered into several agreements between themselves and including agencies of the state of Florida, and they both own part of the Split Oak Forest and they manage it along with the state. In 2019, I believe it was, both counties issued resolutions saying that they were in favor of a location in the very southernmost part of Osceola County that would have allowed for a highway extension, a toll road extension to cut across the bottom of Split Oak. And as part of that agreement, there were going to be 1,550 acres added to Split Oak to kind of more than compensate for the 60 acres that would be impacted by the road. And that troubled some people who didn't want any development at all. And a charter revision committee was formed to consider a revision to the Orange County Charter. And they came up with something that is rather striking in its language. And if I were to try to propose an unconstitutional or invalid charter provision, I think I might start it this way. Notwithstanding any general or special law of the state of Florida and its agencies to the contrary, then it goes on to say what's going to happen. And it's really unthinkable that a county law would purport to act notwithstanding state law. That's just not the way it works in the
Counsel,
hierarchy.
do we in order for Osceola County to prevail on appeal, do we have to make some finding that Article 10 of the charter is unconstitutional? Or is there a way for you to win without it being unconstitutional?
I've thought about that question, and certainly there was no constitutional claim in the second amended complaint, but there was a claim that it was invalid because it conflicted with state law. And I don't know if that's cutting it too close, because it's the same argument, really. The Constitution says state law prevails in the event of a conflict. And we showed that the charter or the amendment, which is Article 10, conflicts with Section 704.0611. That statute says that no law shall be construed to prohibit owners of a conservation easement from considering the development of certain types of things, one of which includes a roadway.
Counsel, I share Judge Brownlee's question. If we grant you the argument that there is a conflict, and understanding that you grounded your argument in the Constitution that there can be no conflict, that the charter can never trump a statute always trumps the charter. But if we find against you on waiver, right? And the only argument you made is grounded in the Constitution, I come back to Judge Brownlee's question, which is that prohibition anywhere else in the law other than the Constitution? Does that come with us to common law? Can you root that in anything other than a prohibition in the Florida Constitution?
Well, I think if you read the language of Section 704.06, it says no law shall be construed to allow this to happen. And in fact, this county law says on it, you don't have to construe it.
But isn't that the problem? If we don't have to construe Article 10, then doesn't that cut against your argument about 704.06? Because it says construe. So, and I take it like, I get the idea that these two things can rub up against each other, right? They look at surface level like they're inconsistent, but it's what you just said. We're not construing the charter, the Article 10 of the charter, right?
You only have to construe something if it's somewhat unclear. In this case, it's on its face. On its face, it conflicts with state statute. So I think that.
But the state statute would be 704, right?
That's correct.
704.06 sub 11.
Yes.
So if that is talking about when we construe laws or language, and we're not having to do that here, how is it inconsistent? I mean, wouldn't we have to read the word construe out of that statute? That's what I'm concerned about this argument. Setting aside the constitutional
I don't think so. I think that's reading more into the word construe, or maybe reading less into it, because you don't have to figure out what Article 10 means. It tells you what it means. It says the Orange County Board may not ever permit removing restrictions on the use of the land in Split Oak. And the statute says that the owner of a conservation easement must always be allowed to negotiate for these types of changes, including
Counsel,
a
what'd you say?
roadway.
It actually doesn't say that. It could say that, it could say may not prohibit or limit. But it says may not be construed, which I think it's Judge Brownlee's point, is this not a statute on the, that basically provides a rule of construction for how we should read?
I just don't think it makes sense to say that a facially violative provision can survive where a less clear provision that might need construction would be stricken. That makes no logical sense in terms of how to view these two laws in.
What do you think the word construe is doing in the statute? What work is it doing?
It's trying to make sure that nobody reads another law in a manner that gets around 704.0611.
So if we accept your argument as true, and we think that that is right, we still have the idea that those two things can only, the problem with them being inconsistent, assuming they are arguendo inconsistent, the problem with that is that it would violate the Constitution, right? So then we get back to this waiver problem that I think might be the elephant in the room. So how do we get around? Is there some way to get around Lee Memorial and the express language of the rule?
I think that Lee Memorial, believe me, I realize Lee Memorial is a hurdle I have to get over.
Yeah.
But there are a number of ways that I can distinguish that case. First of all, the statute that was at issue in that case that was being challenged was in fact, it was a state statute. They weren't construing a county charter amendment. So that is a little different. And as you know, courts, and especially the Supreme Court, they decide the case that's before them. So really, they haven't yet decided what the preservation requirement is with regard to a charter amendment. But assuming that it does apply here, the statute at issue in Lee Memorial was declared unconstitutional for a second reason. So the fact that they never got to Article 1, Section 10 in that case was almost irrelevant because the statute at the end of the day was unconstitutional and unenforceable. And if we don't, in this case, find Article 10 to be invalid, as we argue you should, then you have the one and only, I guarantee you, the one and only county law that purports to operate notwithstanding contrary state law. And that just goes too far in announcing what the scope of the county law is. And so I think, with regard to Lee Memorial, there's nothing in there that suggests that that there was a waiver there. It doesn't really say this, but one must assume that there was an objection to the fact that there was no notice given to the Attorney General. And here, Orange County was completely silent during the entire litigation in the trial court about the fact that the Attorney General wasn't given any notice. And I believe that was a waiver. There are many
But is that
cases-
theirs to waive? This is my concern is there some case where one party could waive that on behalf of a non-party? Like it seems like it's not theirs to waive. And all of the cases that were cited in the briefing and the initial and the reply brief deal with a situation where the party would be waiving its own right. And here it seems Orange County would somehow be waiving that on behalf of both the Attorney General or the state attorney assigned to that jurisdiction.
Well, they're the litigant, they're the party in the case, and that would be a defense that party could raise. And if it's a defense that they could raise and perhaps should have raised, they didn't raise it. And that, I think, constitutes a waiver. And to the
Is it a
extent,
defense, counsel?
pardon me,
Is it a defense?
I think it would be a defense.
It's not part of your cause of action when you ask for a declaration that something's unconstitutional. that
Well,
you-
this is where we get into the tension between one party's obligation to do something, any kind of notice requirement, any kind of condition precedent, and the other party's obligation to object. And this happens all the time. One party doesn't do something that they're supposed to do, and if there's no objection, they get to do it.
But
That goes back to Judge Brownlee's original question. Do you have any cases where it's a non-party?
No, I don't have any cases where it's a non-party, but
Wouldn't that be kind of a bizarre, like, I'm trying to think, if we wrote this the way Osceola County would have us write it, where it was a reversal, and we attack this issue that's fairly raised by the parties at this stage, then wouldn't our reversal, I struggle, so it would say, we find this unconstitutional because 704 conflicts with Article 10, and that sort of thing is prohibited by the Constitution. And it doesn't, the Attorney General and the State Attorney have not had, certainly not a prompt notice of that. So they had no opportunity to be heard. But notwithstanding that, we think that Orange County could waive that rule of procedure and that entitlement to be heard on behalf of the AG's office. That would be, I don't know, that's hard, that's a hard right.
then I think you could analyze the case slightly differently. One is that it would be fundamental error to allow a county provision to stay on the books when it says that it operates notwithstanding contrary state law. That is the fundamental nature of the structure of our government. State law predominates.
But
is
in that state-
constitutional?
Pardon?
Sorry.
Go ahead, Judge Nardella.
I mean, the structure of our government, it violates the structure of our government. That's also a constitutional problem. It may not be a specific, I mean, it's the division of powers.
Right, but I just don't think it makes any sense to allow that kind of language to stay on the books. Let's turn to the breach of contract, because that's another ground. And maybe you can just look at the contracts rather than the contract clause to show that the contracts allow the parties. And when I say contracts, I mean the interagency agreement and the grant award agreement that both counties were parties to, as was the state of Florida. And both of those documents have provisions that allow the parties to amend its provisions when the circumstances require. And I'm just going to refer the court to the record pages. 998, section paragraph 6 refers to modification of the interagency agreement. And at page 1004 in the grant award agreement, paragraph 3, it says this agreement may be amended at any time, and it has to be agreed to by both counties and FCT, Florida Communities Trust. And so what Article 10 has done is hamstrung Orange County's Board of County Commissioners, which had been completely in favor of the Osceola Parkway extension. And it's said that the Orange County Board of County Commissioners may not approve that. And that certainly changes the nature of the contractual agreement here. And I think this court could find that that is a breach of contract and that Article 10 is invalid for that reason.
What provision would it breach?
The ones that I just,
Well, let me ask this. Maybe that was a poor question. The governing documents, the interagency agreement, the grant award agreement, the deed of conservation easement, do they dedicate any provision to saying the mechanism for which assent should be given or agreement should be given by one party?
no, but I think it has to be in writing. It does say that.
But how they internally, and I think this goes back to Orange County's argument, how they internally make that decision. So it's a practice that was incorporated into these agreements. Is that the argument? The practice was that the Board of County Commissioners would always make the final decision. And that practice is no longer in play.
But it's fair to say that Osceola County and the state of Florida would not have entered into an agreement with Orange County in which Orange County was forbidden from ever making any amendments or modifications, because they recognized that amendments or modifications might be a good idea in the future. Now, they still have to be approved by everyone. And it is true that Orange County says they always retained the right to not approve it, but they also retained the right to approve it. And that right has been taken away. That's a contractual expectation. And that breach of contract is clear, even without talking about the Florida Constitution. I know I'm getting into my rebuttal time. I just want to say one thing about the ballot provision and and the summary, because I think that that's an argument that should not be overlooked. We all know what the standards are. The ballot title and summary have to be fair. They have to inform the voters. And there is nothing in either the title or the summary that fairly informs the voters that this pertains to the Osceola. This was motivated by and really is directed at the Osceola Parkway extension. Nor does it tell them that if that extension goes through, that 1,550 acres would be added to Split Oak. So it's worded in such a way that the provision is solely to protect Split Oak, but in a way, it precludes Split Oak from getting the benefits that had already been proposed and at least provisionally agreed upon by the parties. So under Askew versus Firestone and all of the requirements that fair notice has to be given to a voter so that they can intelligently place their vote, I think it really should be stricken from the Orange County Charter.
As a neighboring county, you feel you have standing to raise that?
We absolutely have standing under the declaratory judgment action because we have an interest that is affected by this. I mean, in fact, it's very unusual, but the charter provision lists portions of Split Oak that are located in Osceola County. So it's very clear that they're regulating land that is located in Osceola County.
But you have an interest insofar as they're regulating that land located in Osceola County. I grant you that. But do you have an interest insofar as Osceola County would need to be informed on how to vote on a ballot? Wouldn't those be two different things? So the right to be informed about something and to not have the ballot summary, be vague or ambiguous, or as you're stating, they're not being fully transparent with all the benefits that could flow from this. But that ballot summary to inform voters, isn't that distinct from your Osceola County's interest in just how this is going to affect this agreement and this land?
No, I don't think it's separate because of the 30-year history that the two counties have and the contractual agreements that they've had and all of the efforts that have gone into the whole Split Oak Forest mitigation park. And the fact that Orange County listed our land in their charter provision tells you that it does affect us. And so I think that the standing requirement is not so rigid in a declaratory judgment action that it would exclude us from making the arguments that we're making here today. I'm going to reserve my 1 minute for rebuttal. Thank you.
Mr. Burbon, you're recognized. Oops.
May it please the court. My name is Lee Birnbaum. I represent the appellee of Orange County, Florida. The final judgment entered by the trial judge in favor of Orange County was properly entered, and it should be affirmed by this court. As your honors are now well aware from reading the briefs, appellant's arguments essentially are threefold. One, they say the charter provision is inconsistent with state law. A lot of that is citing to 740.0611, which I'll address. They secondly argue it breaches the governing documents. And third, that the ballot title and summary were misleading.
Can I ask you to go right to number 2 and address her argument about the breach of contract claim and whether Article 10 violates these agreements, the interagency agreement, grant award, deed of conservation?
Yeah, yes, Judge Brownlee, of course. It's our contention. We think that it absolutely does not violate them. Their whole argument about arguing it's a breach of contract is these amendment by mutual agreement clauses. And what they say in each case, and in each case, I mean the interagency agreement, the grant award agreement, and the conservation agreement, all say specifically that the amendment may happen in the future. The interagency agreement, this agreement may be modified, requires approval of all parties. Grant award agreement, the agreement may be amended. The conservation as may be amended by mutual
But we
agreement.
are taking away the word may, right?
Well-
Or are we?
Well, I don't think so, because I think what Osceola is arguing, in my opinion, incorrectly, Judge Brownlee, is that somehow the charter provision and Orange County are separate. Orange County is governed by its charter and its code. Orange County has the right to regulate through laws, in this case, a new law, what it decides to do in the future. It's not like the charter independently prohibits the Board of County Commissioners and what they can do. The charter is an entire governing document in all cases, whether it's zoning or planning issues or how they vote or what public notice. The Board of County Commissioners is governed by the charter. So Orange County has a right through a charter amendment to say, we are not, despite that there were agreements that say these may be amended, we are not going to amend these agreements in the future if such amendment or other agreements have the effect of limiting or restricting the conservation and environmental protections in place. And they have the right to do that. If you have a right, I'm sorry, Judge.
Do you see a distinction between a wholesale prohibition and then a direct vote by the voters on an individual modification? Do you see what I'm saying? I understand your argument, but the fact that they've prohibited, what they've taken off the table is consideration.
Well-
Does it belie these governing documents that there will be consideration given to individual requests for amendments, and that consideration is now being, and I don't use that in the contractual term, that's probably a poor.
I understand. Respectfully, I would say no, because there's nothing in the governing documents or the amendment by mutual agreement provisions I just cited to that say what the process to amend is.
Correct.
They simply say that it may be amended and all parties have to agree, and it has to be in writing. There's nothing that talks in any of the contracts about what the process or the consideration or the interpretation about whether to amend is or is not.
We understand that.
And I'm just trying to answer the question. And part of the other answer, I think, as I cited to in my brief, is if there was no charter provision at all, Orange County would have the absolute right to refuse to amend any of these agreements, whether it related to the Osceola Parkway extension or otherwise. So to have something that codifies how they're restricted is not a violation or breach of those agreements. It
When it-
doesn't change. I'm sorry, Judge.
When it comes to the breach of contract argument and not to the 70406 argument, taking those separately, but when it comes to the breach of contract argument, would the answer be any different if every single county commissioner ran on a promise that they would never amend?
And when you say would the answer would be different, can I make sure I understand your question?
Sure, and maybe this is a better question for opposing counsel, but if every single county commissioner ran on the fact that I promise my constituents, I will never amend Charter Oaks,
Mhm.
I'm sorry,
Split up.
would
Yes,
never
ma'am.
amend Split Oaks. Would that be a violation?
No.
Would that be a breach of contract?
I'm sorry, I didn't mean to interrupt. No, I don't think at all. I think any commissioner, whether it's a sitting commissioner or challenge, could run. That can be part of it. Often they do run on issues regarding the environment and development or not development and where it will be. No, I think they have the absolute right to do that.
So
I
if
guess there could be
voters weigh in
a,
in two different ways. Does it matter? Voters weigh in through electing a county commissioner who says, I promise to never, ever, and voters weighing in through a ballot initiative.
no, I don't think it does matter. And in this case, 86.4% of the voters decided to approve this charter amendment. And by doing it, they're saying, we want this protection in there. We want this restriction on what the county commission can or cannot do as it relates to Split Oak, whether amending existing agreements or future agreements. And I think there's a right to do that. I don't think there's a distinction, to answer your question. And
Do
I
you
think,
think that that breach of contract claim is dependent on a constitutional argument? Or do you think it stands alone from that? I mean, I know that it was, I think, my recollection at least is that in the briefing, it was in the context of, not impairing the contractual rights. Bless you, Judge Stargell.
yeah, candidly, Judge, no, I think they can make those independently. As you know, and as your honors asked opposing counsel, I think their claim that the contract is a violation of the Article 1, Section 10 impairment of contract clause, I think they've clearly waived that. They didn't file a notice under 1.071. And one thing I want to correct about that before I go back and address the rest of your question, Judge Brownlee, is appellant's counsel said that Orange County never raised that in the litigation. Well, they never raised the constitutional argument. The second amended complaint, the operative complaint, made no claims whether because of Article 1, Section 10, or Article 8, Section 1G, that any part of the charter provision was unconstitutional. Their prior iterations never raised it. In 3.5 years up to the summary judgment motion, they never raised it. They raised it for the first time in their response in opposition to the summary judgment. And they, even then, they never filed a notice of constitutional challenge. They never put State Attorney General on notice. The first time they did that was in the appeal. And a month later, I objected to it, said in all the cases, Lee Memorial Health System, because the Florida Supreme Court case is probably the most relevant, but every DCA has said courts are prohibited from addressing that issue when they don't do it.
Do
But
they-
I agree that
Do those cases, counsel, with regard to this notice provision, the purpose of my question is to discern whether it matters that the trial court found it was constitutional as opposed to unconstitutional. Do any of the cases relied upon by Orange County involve a situation where there was a notice problem, but there was a finding of the trial court that it was constitutional?
not that I'm aware of, but this is a little bit different because, in my opinion, Judge, because they challenged the charter provision saying it's invalid. And so, yes, part of our argument was, hey, a charter provision is valid as long as it is not inconsistent with Florida Constitution, general law, or special law. So we made that affirmative statement as part of our defense and as part of our summary judgment motion, because that's part of the standard. The case law goes on to say where there is no direct conflict, appellate court should indulge every reasonable presumption in favor of the validity or constitutionality of the presumption. So to answer your question, no, I'm not aware of the Lee Memorial case or another one where the trial court said it's constitutional, but I think because of what they challenged and what the standard is, that's why it came up here. But there is, I would also point out, there's no difference or distinction between the Lee Memorial cases or this case. I think any attempt to do so is really kind of twisting yourself in a pretzel. There was no fundamental error alleged in any of those cases. It was the exact same situation in Lee Memorial as here, and that is they tried to raise a constitutional challenge way too late in the game. They tried to file a notice of challenge, a notice to Attorney General way after they were supposed to, and in non-compliance with a rule that said it has to be prompt. And the court said, you cannot do that. We cannot consider it. To answer your question, though, I want to make sure I did answer it. I do believe that appellant can make the argument that the provision is a breach of contract without having to just say it's an impairment of the contract. And so we address that. And my counter really is there is no breach for the reasons I've said before. And that is, if we have a right to not amend in the future, regardless of a charter provision, and all the charter provision does, a governing document of Orange County, is say Orange County is not going to amend, not going to exercise its right to amend in the future under certain circumstances, it's perfectly valid to do so.
Is it almost like an impossibility argument? I mean, sort of what good is the contract at this point until the voters speak again?
Well, I don't know that I would argue that. I mean, the contract has a lot of provisions. The interagency agreement and the interagency agreement governs between Osceola, Orange, and FWC and governs the management of that land and the setup. It's still in place and it still goes. The grant award agreement, which had to do with state through FCT funding to the recipients, Osceola and Orange County, is still in place. No amendment has even come before. There's nothing in the record to show any amendment has come before the Orange County Board that has been rejected. And again, there is an exception where Orange County, in the charter provision, where Orange County's Board of Commissioners do have the right to approve an amendment or a new agreement related to Split Oak if it provides greater additional or more stringent protection. So no, I don't think it's an impossibility. They've just set very strict standards under which they will or will not be permitted to do so. I want to address 740.0611, if I may, as well, which is, I think, the main argument, and I want to speak for appellant, but the main argument where they argue it's inconsistent with state law. And it simply is not. You have to look at 704, respectfully, I would ask the courts to look at 704.0611 in the context of the entirety of 704.06. And that's what all rules of statutory construction say, is look at the clear, plain language of the statute, look at it in the context. So 704.06 talks about conservation easements and the protections under which they serve. 704.06 1 and 2 express that conservation easements are perpetual and run with the land and are binding on subsequent owners. It talks about how there can be a prohibition on conservation easements for the construction of roads and other activities inconsistent with wildlife, water, vegetation. And subsection 4 also talks about how they run with the land. Now, all 704.0611 then comes in and says this section nor other law. So despite all the protections that you have for conservation easements, and despite that they're perpetual, is don't interpret that to mean that the owner of a land or owner of a conservation easement over land cannot voluntarily negotiate. It says, you know, a law may not be construed to do that. Our charter provision, first of all, doesn't construe 704.06 at all. It doesn't say that we are putting in this prohibition because 704.06 or any other law requires conservation easements to never have roads. It was a separate document. It doesn't indicate how Osceola County has to construe it. So the word construe is critical. Contrary to what I think appellant has argued, at least in their brief, 740.0611 doesn't say no law can limit voluntary negotiation. It says this section or other law may not be construed to prohibit it. So this provision, especially when read in the entirety of 704.06, first of all, is entirely consistent with our charter provision. It doesn't require roads to be put on conservation easement. And again, Orange County can decide whether or not to voluntarily negotiate, hence the word voluntary. And this is, again, where I think Osceola County is trying to make a distinction between the charter and Orange County. It's the same thing. This is a mechanism, the charter provision by which Orange County said, we are not going to voluntarily negotiate. And so there's nothing at all inconsistent with 704.0611 and with the charter provision. And that, I think that's true just on the face of the statute, but I would also, and I think I cited to it before, the city of Kissimmee versus Florida Retail Federation Incorporated Fifth DCA case, which says where there is no direct conflict, appellate court should indulge every reasonable presumption in favor of the constitutionality of the provision. Now, I want to talk, and I'll circle back if I have time, of course, answer any questions, but as to the ballot language, we don't believe Osceola County has standing. And to be clear, our argument about their lack of standing to challenge the ballot summary is different. We're not making an argument that they do not have standing to challenge the charter provision through a declaratory judgment or otherwise. So I think Osceola is kind of conflating two different standards. Do they have standard under Chapter 86? Do they have standard to challenge a ballot language? And the city of Hialeah versus Delgado case, which we cited to, makes clear that it is a voter or a citizen of the county that has standing, period. And in fact, the city in that case even tried to make an argument that the person challenging the city ordinance didn't have standing because they were making a tax. The city mixed up standing to challenge an election and a taxpayer standing to challenge how a state uses certain revenue and whether they're directly impacted. And in that case, the third DCA directly said, no, Delgado has standing under to challenge, make a 101.161 challenge because he is a voter and a citizen. Osceola is neither. It has no standing to challenge the ballot summary. That being said, based on the clear case law, and the trial court correctly found, the ballot summary meets all the requirements. It states the primary purpose of the charter provision, and it is not affirmatively misleading. As this court knows, most of these go before the Florida Supreme Court, who often issues advisory opinions, and the standards are really clear. And what the courts have consistently said in the Florida Supreme Court is that a proposed amendment, and this is true whether it's a constitutional amendment or a charter amendment, should only be found invalid only if the record shows it is clearly and conclusively defective, meaning it's clearly and conclusively misleading or fails to state its chief purpose. That is absolutely not the case here. And I think one of the most important cases is the most recent one I cited to from the Florida Supreme Court on election challenges. It's the advisory opinion to the Attorney General regarding limiting government interference with abortion. And in that case, the Florida Supreme Court talked about what the key question is and what the key question is not. And it says, while it may be true the proposed amendment could have broad effects that are not fully explained in the ballot summary, a ballot summary does not have to explain every detail. It doesn't need to provide an exhaustive explanation. It's looked at as if the voter would educate herself or himself on the possible effects. The Florida Supreme Court in that case also went on to say, the question is not whether the proposed ballot language is free of ambiguity or whether there are uncertainties on the legal effect. They also said this court doesn't have the authority to rule on the merits or wisdom of it. What the court is simply doing is looking at the ballot language and the title and summary and comparing it to the text of the charter provision itself. And the trial court did it in this case. This court can do it, and they are entirely consistent with each other. The argument made by Osceola County that somehow the ballot summary in 75 words or less had to include talk that this was motivated by the Osceola Parkway exchange and there could be more acres coming to Split Oak is just simply not required by any reading of any Florida Supreme Court case. Additionally, while clearly the Osceola Parkway exchange was the impetus for the charter provision at issue, the charter provision isn't limited to the Osceola Parkway extension issue or contracts related to that. Instead, it's related to the Split Oak forest as a whole and any amendments to the existing governing documents and any new agreements that would restrict it.
Should we be troubled by the language in the beginning of Article 10, notwithstanding any general or special law of the state of Florida? What about preemption?
Yeah, thank you for bringing that up, Judge. And I meant to address that to talk about it. It's inartfully worded. However, when you look at the charter provision as a whole, there is nothing in it that indicates Orange County believes, contrary to all the law, which we know, that the charter is contrary to state law. In fact, the rest of the charter provision, you see provisions where we expressly recognize the superiority of state law. In fact, it says in the severability clause that this provision should be interpreted consistent with superior state law and superior federal law. We know that state law is superior, and there's nothing in this, when you read the provision as a whole, that is intended to supersede that well-known effect. For all those reasons, I'd ask that this order be affirmed. Thank you. Sorry to go over, Judge.
In my 1 minute, I would just like to point out that they knew when they gave this to the voters that it was a problem. If you read Exhibit I to the motion to the second amended complaint at page 1040 of the record, the Split Oak Forest Committee recommendation acknowledges in the section called Arguments Against Recommendation that Florida law permits transportation corridors and linear facilities, which are roadways, through conservation easements. And they go on and they talk about section 704-0611. They knew this was a problem. And nevertheless, they submitted it to the voters knowing that it was a problem. And now that problem is before this court. He talked about, Counsel for Orange County talked about the language in the agreements that says that they may be amended. And now what we've got through Article 10 is that Orange County may not amend them. And yes, it always had the power to say, we don't want to at this time, but now they don't have the power to say, we agree. And that's the problem here. This court should reverse the summary judgment.
Thank you, Counsel. Right. Thank you for the informative arguments, and with that, court is adjourned.
Thank you.